on and off of your property at all times. Delivery people, the mail carrier, vendors, and other guests. As a landowner, the question is always, what liability do you have if one of these guests were to trip and fall in your walkway? Hi, I'm Julia Way, a real estate attorney here at the law offices of Peter and Brewer. One of the things that I constantly advise my landowner clients and real estate investors is to maintain safe condition on their properties. In my recent blog article entitled Mind the Gap, I discussed the recent case of Chatham versus Somerset Garden Townhouse HOA. In this case, the court concluded that a landowner, even if they know of a potentially dangerous condition in their property, has no liability if it's a trivial condition. Ms. Chatham lived in a townhouse in Santa Barbara, and while walking in the common area, she tripped. Her fall was so serious that she had to have 6 surgeries over a 2.5-year period. She later sued the townhouse HOA and the property management company. During the trial, the jury concluded that she had been damaged in the amount of $1.3 million and awarded her that amount. The HOA and the property management company brought a motion before the judge asking him to reverse the decision. The court did grant that motion, and accordingly, Ms. Chatham had to appeal. On appeal, the court discussed the trivial defect doctrine, wherein a landowner would not have liability if the condition of the walkway was such that it would be impossible to maintain in an absolutely perfect condition. In the case of Ms. Chatham's, the gap in the walkway was less than an inch, and so the trial court had concluded that it was trivial, and therefore the landowner had no liability to Ms. Chatham. The appellate court concluded the same and affirmed the decision. In addition to looking at the actual size of the gap, the court looks at the conditions around the potentially dangerous condition. So in this particular case, there was good lighting, there was no overgrowth of the surrounding landscaping, and therefore the court concluded that a reasonable or ordinary person should be able to see the condition. So essentially, the courts are saying, mind the gap. To read this article and other insightful blog articles from attorneys at this firm, please visit www.bayarearealestatelawyers.com.